You can win every liability battle and still lose the war on damages and lose your case.
So yeah, we've had several stroke cases. Recently we had one involving a procedure where someone suffered a stroke afterwards, and as you know, sometimes the damages might not be something that's visible to a jury. So when you have a case like that where the damages aren't something that, you look at the person and you can see it right away, I mean, what are some of the ways that you can show the jury what the actual damages are in a case like that?
Right, yeah, in this case, he fortunately made a good recovery, as a lot of stroke patients do, made a good recovery. If you met him and didn't know him, you would never think that he suffered a stroke, right? So we spoke to the wife, and he has an amazing wife who's a very strong woman, and she gave us a lot of information about what was like that a year after the stroke, where he was going through the recovery, right? And what life was like. And he was a super hard worker, tried so hard to maintain his job in sales. And he went back to work 3 times and just was unable to do so. And his wife had a lot of stories and details that she was able to provide us. And I remember that we wanted to capture that in real time. And so we went out there with a person who helps film day in the life videos, and also video depositions, things like that, and just kind of went through a more relaxed deposition with her, and had her say in detail what she witnessed during that first year in the recovery. And I remember that we wanted to get testimony from his boss, because we thought that would be really helpful in telling the damages and the damages story. And the employer was a large corporation, and for whatever reason, they wanted no part of it, which was very frustrating. Because here you have a person who's a 25 plus year employee for this company, and is given this company the best of himself, and the boss won't even agree to be a witness and talk about how he was before and after, because how we tell our client's story, it's one thing for the injured person to go up there and say what he was able to do before and now what he's able to do, but that, if it's you talking, it comes across as whining, it comes across as self-serving. And so having neutral third-party witnesses is what we want. We were able to find a coworker who was willing to talk, and I got the impression that he was told by HR not to speak with us, but fortunately he did, and he gave us a lot of information about the projects that our client led before his stroke, and about him coming back and trying to step back in that leadership role and being just completely overwhelmed and looking exhausted and looking out of it, and his colleague just realizing that's not him. So that was helpful, and his brother, our client's brother, was really helpful, and told a powerful story about them going back for their parents' 50th wedding anniversary, and a car broke down, or the rental car had some trouble, and that before the stroke, our client would have loved the opportunity to tackle this challenge and to be there and to fix the car and to solve the problem. That he was just great in situations of crisis like that, and then after the stroke, it was just completely overwhelming to him, and he shut down, and then lashed out and got angry, and they just had to realize that it was part of a brain injury.
So oftentimes we have, delayed diagnosis cases and strokes, for instance. Sometimes you're going to have a case where the patient's suffering from a stroke and you're alleging that, they didn't get to it and diagnose and treat it soon enough. In some of those cases, that there's going to be some residual injury related to the underlying stroke itself, but we're claiming there's a delay in diagnosis which made the injury much, much worse. In those types of cases, what are some of the most effective ways that we kind of distinguish, the initial injury from what occurred as a result of the delay?
Yeah, that's really challenging, and that's your job, Carter.
Yeah.
You get to go and cipher through the medical records and the images and figure out how to prove the worsening of it. What are some of the things that you did to help prove that it was the delay that caused the damage, not just the stroke itself?
Well, a lot of times you look at the medical records themselves and you can kind of see what the patient's condition was at the start of the stroke versus at the end of this delay, and look at whether it's nursing assessments or look at the imaging, and then you have an expert look at the imaging, and if there's imaging from the early parts of whatever it is, if it's a stroke or whatever the injury it is, if there's imaging, then the expert a lot of times can look at that and then compare it to later images and hopefully point to areas where there was additional damage to the brain, for instance, that will show additional injury that occurred as a result of the delay. So a lot of it depends on what an expert can help us with. We need them to sort of look at imaging or look at the records and be able to point to different injuries that would be a result of a delay as opposed to just the initial injury itself.
And what type of experts do we use for that?
A lot of times, if it's a stroke case, we're going to use a neurologist or a neurosurgeon. You might have someone who does an independent medical evaluation on the patient, who can go actually examine the patient and see what their deficits are, and then you can look at the different portions of the brain that were affected and have the neurologist hopefully tell you what areas of the brain affect what part of the body, and sort of use all those things together to help build that story of how the person was injured.
We'd like to limit how many experts we use. One, we want to conserve our clients' money. With each expert is an additional several tens of thousands of dollars. But two, you want to have one voice, and the more people you get, the more voices, and the narrative can kind of change. But what we found in the stroke case is that our neurologist likes to have the support or confidence of a neuroradiologist as well, right? And so what are some of the reasons to go with a neurologist, neuroradiologist versus a neurosurgeon?
Well, I think, the neurologist, with the help of a neuroradiologist, they both interpret these types of images, but a neuroradiologist has additional training, especially when it comes to looking at images of the brain. And so I think sometimes it's helpful to have that opinion coming from two different types of specialties that work together in real practice, so they can, in real time, a lot of times you're going to have a neurologist and a radiologist or a neuroradiologist who are both looking at images for a patient, and they're working together to sort of help come up with whatever the impression is on those images. And so I think it's effective in front of a jury to have both of those experts, because one can opine not only on the imaging, but he can also talk about the treatments that would be expected, based on the what's going on with the brain. And so the neurologist is the person who's going to do the actual hands-on treatment. They're going to be the one to decide whether the patient's going to get TPA or whether they need some type of surgical intervention if it's a stroke. And the neuroradiologist is really the one who can help look at the brain and kind of, decide whether this is the type of stroke or injury that needs certain types of treatment. And so, it sort of just depends on the circumstances. If you could have one person do it all, it might be best in some cases, but a lot of times they like to have someone back them up just to, bolster their credibility in front of the jury.
Right. And in the recent stroke case that we were able to get resolved on the shortly before trial, what were the challenges presented in the delay, and then in proving that the delay in recognizing the stroke and cause further harm?
Yeah, so when you have a stroke, there's a known sort of standard out there in the medical community that you have 4.5 hours if it's a stroke that would be susceptible to TPA, which is the clot busting drug. If it's one of those strokes that's in the area of the brain that they think that would be effective and there's no contraindications for giving it, there's sort of a known time frame of 4.5 hours from the onset of symptoms is when you give that medication. Now, sometimes you might have a situation where the doctors don't feel like it was necessary given the severity of symptoms. They don't think that the TPA would have been super beneficial to the patient. And so when you have the underlying delay and you're alleging a provider was negligent for failing to get the patient to the hospital on time, you also have to consider the fact of when the patient actually got to the hospital, what kind of treatment did they do for them, because that's certainly going to be a challenge if the patient gets to the hospital and they didn't do any treatment for the stroke. And those aren't defendants in the case. You're alleging that the initial provider was the one responsible for a delay. Those are just challenges that you have to deal with, but at the end of the day, there's other factors you can look into. What did the hospital know when the patient arrived, and would that have changed their decision on whether or not to give the TPA or not?
Right, and in our case, one of the issues and contentions that we had is that if the provider had recognized the stroke when they should have, not only is he getting to the hospital much sooner, but the hospital is getting information. Hey, this guy's suffering symptoms that appear to be a stroke, and so they're ready when he arrives, as opposed to the triage folks having somebody being brought in by a family member or babysitter or something and trying to figure out what's going on.
And are there certain kind of expert witnesses that we can use to help sort of establish what those numbers might be in an injury case?
Yes, there are. You can use an economist, and an economist can go in and measure but put a number to what the lost wages would be, and then establish a framework for how those wages would have grown over time based on the career projection of your client. And then, because you're going to be asking for a finite amount of money at trial, you reduce that to present value for a single number at the time of trial. So you can use an expert economist to help in that, but that's just the tangible loss, right? I mean, most of our clients, the intangible harm, the day-to-day things that they're not able to do, the personality changes if somebody has a stroke, or the different relationship that they have with their spouse, with their kids. Those intangible losses are many times just the economic loss, and we certainly want to present our clients as people, not as little economic units, right? And show that intangible loss and intangible harm to a jury, and there's not really any expert that can do that. That has to be that story has to be told with the loved ones, friends, and family who are close to them and can give vignettes, which are just small stories about their lives before and after the stroke that create a powerful image of the loss.
Yeah, I think also going back to meeting with the client in their home and just meeting with them multiple times and spending a lot of time with clients helps to kind of get you to understand what are all the things that they suffer from, because sometimes when they're living with certain injuries for a long period of time, they stop thinking about things. You know, they don't realize how affected certain aspects of their life might actually be by their injuries. And so I think it's helpful when we're meeting with them and constantly kind of going over everything as far as, you know, what issues do they have in their day-to-day life, what challenges, and it helps them sort of think about these things. So then when it comes time for them to testify in front of a jury, they're better equipped to talk about it, because sometimes it's not easy to do. And I think the more often you're sort of letting these things be known to other people, it becomes easier. And so,
right, I think it's really hard. And if you've lived with years with an injury, right, it's your new normal, and you forget how you were before, and it certainly is super hard to articulate it, and it's even hard for those that live with the person every day too, right? Because they're now living with the new normal and immersed with it day to day. I think, you know, that's where if you have somebody who, like in this stroke case, the brother, because the brother lived out of town, and so the brother would only see him, you know, a few times a year, and could really talk about the change in before the stroke and after the stroke. We have another case, and we're talking about how important it is to go out to somebody's home, where her neighbors have, you know, just really stepped up. I mean, it's just such a great story of community, and tells what a great person that she is, about how many neighbors came and helped mow her yard, build a wheelchair ramp, made other small improvements to her home, bring her dinner. Those are great folks that can help tell your client's story, and make a powerful impression to the jury, not only to hear it from an impartial witness about what your client is like before and after, but if you have this person has this big a wide network of support, I mean, it tells what type of person they are, right? To develop those types of relationships that the community just comes out and supports during their time of need.